inaugural speaker event for the year. I want to first acknowledge that Simon Fraser University is on the unceded territories of the Coast Salish peoples, including the Tsleil-Waututh, Coquitlam, Squamish, and Musqueam nations, and we're respectfully thankful to be here as part of the talk today. I also want to mention that we have a couple of other speaker events coming up throughout the semester, so stay tuned for those. Announcements will be coming out for them. But specifically, we have Zhu Feng coming with a virtual speaker event from the University of Minnesota that will happen at the beginning of November. And then we also have our travel logs, which is an informal set of presentations from grad students and alumni and faculty members talking about their experiences in the field. So we're excited about having all of those events this semester, and we welcome you to be a part of those. We're very honored today to have a special speaker, and I'm going to ask our own May Ferralis if she would come forward and introduce him for us today. Thanks, May.
So a little bit about Michael Fabris. He is of Blackfoot and European descent, and he sees himself as part of the Indigenous urban community here in Vancouver. And his research focuses on thinking through dispossessions, and dispossessions particularly in settler colonial contexts, which is what we're going to hear about today. His current projects run along two tracks. For the first, that we're not going to hear about, but hopefully if there's questions about it later, you can ask Michael yourself. He is thinking through questions of Indigenous social movements and Indigenous resurgence in urban setting. And what we'll hear today is his current research project, as he's an affiliated member, or affiliated with
Piikani,
the Piikani Nation. We'll hear about it later down. So I just wanted to take this chance to welcome Dr. Michael Fabris to the Geography Department at SFU. He was an undergrad here. Not too long ago. So welcome him back in any ways, and if you can please join me in welcoming Dr. Fabris.
Oh, okay, so the mic, clearly the mic is on. Yeah, so just want to thanks to everybody who's here today. And we'll start by acknowledging that I'm sharing this presentation on the unceded territory of the Tsleil-Waututh, Coquitlam, Squamish, and Musqueam nations on which the campus is located. And though my current research and talk are focused on Indigenous territories and waters elsewhere, I hope some of what I present here today resonates with the struggles of the nations here who are grappling with the impacts on the lands and waters from both past, present, and planned extractive projects and industries, including the TMX expansion. So hopefully I can implicitly mobilize this acknowledgement of the territory that I'm on throughout my presentation, rather than just something that I sort of tokenistically drop at the beginning and then have it forgotten about. So as May. That's embarrassing. I've known May for like well over 20 years. So she mentioned with a great introduction, my name is Mike Fabris, and I'm Blackfoot. I'm affiliated with the Piikani Nation, though I was born and raised out here in the greater Vancouver area. And I've been based in East Van now for 25 years. And I'm also an assistant professor at the UBC Department of Geography. I did do my BA here at SFU, but in several stages. So I think my first semester was in 2020, and my last one was 2000. My last semester was 2014. So it was over a long period. But yes, I did. I feel like it's like I technically did my geography department here because there was so much turnover. But all of my degrees have been in geography. So the research that I'm doing, I'm in conversation with scholarship from within both geography and Indigenous studies, largely addressing the relationship between law, settler colonialism, and Indigenous dispossession. For the current project that I'll be presenting on today, I'm looking at attempts by the Piikani Nation to challenge the construction of the Old Man River Dam. And since Piikani attempts to challenge the dam within the courts, both provincial and federal, were a major part of this story, I'll be focusing today on what's known as the Piikani or Pigan water rights case. And through analysis of this case, I seek to answer what are the limits of decolonial manifestations of Indigenous law when expressed through Canadian and other settler forms of law. And the research that I'm presenting, it's an ongoing project, but at least the first stage is finished. I did largely two forms of research, expert interviews that I conducted from 2018 until the end of 2019, as well as some archival research. And the experts that I interviewed were mostly Piikani elders, community activists, and advocates, as well as both past and present band council members. Thanks, May. Most of whom were directly involved in trying to challenge the Old Man River Dam, or some who at least wanted to share with me more about their experiences and knowledge related to the Old Man River. And as you can see, this is a picture of me with my cousin Edna. This is, I guess, the last trip I made as part of the interviews. If I remember correctly, this is the parking lot of the co-op in Pincher Creek, which is a town just west of the reserve. When I first started talking to my family about my ideas to do this project, Edna was one of the people that offered to help me with the project and with connecting people that have been involved in the various attempts to challenge the construction of the dam. So I did hire Edna. She was paid to help me as a research assistant, and she accompanied me to most of the interviews. And I did also interview some people that I'd already known from my previous time that I've spent on the reserve over the last 20 plus years. But Edna played a really crucial role in connecting with people to interview. And for my research, I'm drawing on self-reflective approaches, drawing from traditions both within Indigenous studies and geography, with respect to the positioning of being an insider-outsider in the research. Because again, as I started connecting with my relatives on the reserve over 20 years ago, but I was not born on the reserve, I grew up out here. And this project is the first time that I've attempted to make Piikani histories, experiences, perspectives, and struggles the focus of my academic research. And some of the people I interviewed that had not met me prior to this research, and it was only through the support and involvement of my cousin Edna that I was able to connect with many of them. And within Piikani protocols, who and how a person is known within the community based on their relations is extremely important. So by connecting and introducing me as a relative, as a family member, despite meeting many people for the first time, Edna played a really important role in setting a tone for the interviews that I conducted, and helped establish that trust for more, fruitful and very generative conversations that I was fortunate to have with the people that I interviewed. And I think one of the most significant sort of outcomes for this research for me personally is the new relationships that I established in that process. And these relationships will continue long after the formal end of the academic research project, as it were. So I look forward to returning to the reserve. I've actually got plans to go back in the spring, partly to continue the conversations that I began, but also as part of that relational accountability that comes with doing research with one's own community. And also, in terms of the archival aspect of the research, I don't touch on it too much, but I also do want to acknowledge Eldon Yellowhorn, who's been, a mentor in many different ways since I first met him, 20 years ago. But when he heard that I was doing this project, was very generous with sharing some of his own archival research. So I just wanted to acknowledge that. I really appreciate that you shared that with me. In terms of the methodology, I primarily theorize Indigenous law through Indigenous people's experiential knowledge, supported by my archival research. Piikani scholar Betty Bastian describes the importance of experiential approaches to research, wherein research is, quote, a journey of relating, participating, and understanding one's relatives. The sharing of knowledge, then, is inseparable from the relationships and responsibilities between those sharing it, whereby, quote, knowledge arises in a context of alliances and reciprocal relationships. These words from Bastian really resonated with me as I reflected upon the interviews that I'd conducted in preparation for writing this research. And many of my findings and theorizations emanated from these conversations that I had with the people I interviewed, rather than strictly treating my interviews as sources of empirical information or data, from which I then generalize as a relatively detached researcher. So it's in this regard that I don't see, that I do see the Indigenous, the Piikani members that I interviewed as experts, and that these were expert interviews that we were conducting. Because in their own way, each of the people I interviewed is an expert in the enactment of Piikani and Blackfoot traditions of land-based practice, water relationships, and law. And at the same time, in terms of the theoretical framework for this research, this grew out of my own previous interests, which a lot of you would know. I've been more focused on thinking through an Indigenous critique of political economy and the relationships between dispossession law and capitalism. And this led me to a re-examination of some of the articulation and modes of production debates, largely from the 1970s and 80s. And these are writings that not only address the continued workings of primitive accumulation, but in examining its specific workings, demonstrated how different subjects are both interpolated by and resist capitalist dispossession at a variety of sites and scales. In an influential but highly critical analysis of the modes of production literatures, there we go. Foster Carter noted how, rather than theorizing capitalism's relation to other modes in terms of succession, stages, transcendence, or dissolution, quote, this capitalism neither evolves mechanically from what precedes it, nor does it necessarily dissolve it. Indeed, so far from banishing pre-capitalist forms, it not only coexists with them, but can buttress them. And additionally, many of the other articulation theorists noted how not only does the word articulation have two different meanings, but that both of these meanings have utility within critiques of capitalist relations. And one person who broke down this definition was Post in his 1978 book, Rising Starlings. And as he put it, describing the definition of articulation, its two levels of meaning in English convey the two levels of relationship among structures in a social formation. To articulate means both to join together and to give clear expression to something. In this way, we can speak of the conjunctive and expressive levels of articulation. So, early on within this research, then I was trying to bridge my two main interests of economic geography and Indigenous law. And this is where I started to think through whether this originally Marxist conception of articulation may help theorize the relationships between Indigenous and settler forms of law. So in my current project, I'm drawing from the Marxist conception of articulation, but in conversation with Indigenous legal scholarship. And rather than focusing on more narrowly defined economic relations, or attempting to develop an Indigenous political economy, which was something I'd planned to do and put aside for now, what I'm trying to do is center Indigenous legal orders as sites of struggle, and exploring how Indigenous orders of law articulate both with Canadian law and through Canadian law. This is because, as I argue, in struggles against the capitalist reterritorialization of Indigenous places, it is often through the assertions of competing legal jurisdictions that these struggles tend to find their most profound expression. So this emphasis then on Indigenous law and legal orders is partly to prioritize our own approaches and our own understandings of theory and political struggle within our resurgence frameworks. The revitalization and resurgence of our own legal orders includes the governance of land relationships, which partly includes the economic, that also includes interpersonal relationships. So prioritizing Indigenous struggles on our own terms means centering our own forms of jurisdiction as a site of struggle, and the ways that Indigenous opposition to capitalist colonial violence are often expressed through these assertions of our own forms of jurisdiction. So here, in settler colonial contexts, Indigenous struggles over jurisdiction become, to borrow from Stuart Hall, quote, the modality through which classes lived. So I find this is a useful framework for analyzing some of my main research questions, which involve understanding not only where, but how Indigenous legal orders meet with settler forms of law. In these meetings, at least those which form the case studies of my research right now, Indigenous legal orders tend to exist in a complex unity with settler forms of law. And consequently, we often attempt to express our own senses, our own understandings of law through the language and institutions of settler colonial law, such as the courts. And finally, I draw from this conception of articulation as a way to intervene within discussions amongst Indigenous legal scholars about legal pluralism. It's one thing to insist that as Indigenous people, we have our own forms of law and governance that exist separate from and prior to settler expressions of law, jurisdiction, and sovereignty. But I'm trying to ask, what are the actually existing relationships between these different forms of law? And does the language of pluralism imply that Indigenous and settler forms of law exist side by side on parity, and thus serve to obscure the ways that attempts by Canadian and other settler states obscure their attempts to subsume our own legal and political orders? So, in other words, I'm hesitant about theorizations of Indigenous legal pluralism that operate on the assumption of deficit, whereby the formal or additive incorporation of Indigenous legal orders into settler common law is the end goal for Indigenous communities. Instead, I suggest articulation provides a means to specify the kinds of already existing relationships between Indigenous and settler forms of law. Legal pluralism does happen in a context of domination, within which Indigenous communities are often forced to find ways to creatively articulate our own legal relationships with our lands and waters through that which is available within settler colonial law. Okay, the people closest to me are at least 6 feet away, and I'm just, I'm very fine with the mask, but the humidity within my face is overwhelming me. So, these are the concepts and the questions I've just been discussing are the main things I'm trying to work through within my research on the Old Man River Dam and attempts by the Piikani Nation to challenge the construction of the dam. The Old Man River, for those who don't know, runs through what is currently southern Alberta, starting within the Rocky Mountains, and it runs generally eastward and eventually connects with the South Saskatchewan River. And the official English name of the river is based on the Blackfoot name, which is Napi Tata. And this name derives from a creation story related to the river's origin. And the basin also forms a key part of traditional Piikani territory. The Old Man River Dam was first proposed by the Alberta government in the early 1970s. And it was originally built primarily to increase irrigation capacity for southern Alberta's agricultural economy. Though a hydroelectric plant was also added to the dam's infrastructure in the early 2000s. And the original construction of the dam started in 1986, and it was completed in 1991. And the Old Man River Dam is located just west and upstream of Indian Reserve number 147A, which is the main reserve set aside by the federal government for the Piikani Nation, formerly known as the Piegan. And from the federal government's perspective, The reserve was established under the terms of Treaty 7, which the Blackfoot Confederacy, along with 2 other Indigenous nations, negotiated with Crown representatives in 1877. However, to the present day, many Piikani Nation members challenge both the reserve's boundaries and the nature of Treaty 7 itself. Within Blackfoot oral history, at the time of the negotiations, the Blackfoot Confederacy members involved did not view the treaty as a land surrender agreement, which is a Canadian government's interpretation, but as a peace treaty to negotiate the sharing of Blackfoot territory with newly arriving settlers. According to Blackfoot scholar Leroy Littlebear, the Blackfoot word for treaty itself translates to making peace, whereby treaties between Indigenous nations and the British and Canadian authorities, quote, were to be instruments guaranteed the continuity of the Indian way of life. This Blackfoot understanding of Treaty 7 as a treaty of alliance and not one of land surrender is thus reflected directly within the Blackfoot language itself. And further, these Blackfoot oral histories suggest that as an embodiment of our own legal, political, and spiritual traditions, Treaty 7 represents the continuation of Blackfoot political authority and jurisdiction, and not their surrender or their termination. And when Piikani members were expressing, or attempting to challenge the Old Man River Dam, there was a question of what legal avenues the nation had to challenge the dam when it wasn't located on reserve land. However, this is part of the issue, that within these different understandings of the treaty, the meaning of the reserve and where the actual borders of the reserve should be are different than that which the federal government recognizes. And one of the elders I spoke with, Leander Strikes with a Gun, who was involved on Chief and Council and involved in opposing the dam, as he explained during our interview, he said, this is the reserve according to their interpretation of the law, what the reserve means. But we're looking at the bigger land base. We're saying this land belongs to us. The reserve starts from the mouth of the Old Man River, west in the mountains, to the South Saskatchewan River, and then down to the U.S. side, Waterton Lakes. That's all part of Piikani. So through this and some of the other conversations I had with Leander, he was sharing this Piikani perspective on both the nature and the true size of the reserve. Here, though, Leander was also talking about how around the same time that the dam was being built, the nation had been considering a different lawsuit known as the Big Reserve case. And this was to attempt to argue in court that the current Piikani Reserve is much smaller than what it should be based on the Blackfoot interpretations of Treaty 7. So this is like arguably a bit of a different issue, but I think this perspective, this sort of Indigenous legal consciousness about Piikani territory, and the way that Piikani and Blackfoot jurisdiction extends far beyond like the existing reserve, I think this played a big role in how Piikani members thought about the dam and thought about ways to challenge the dam, even though it was not constructed within the federally defined boundaries of Reserve 147A. And at the same time, just to be clear, like within the community, the nation and its members attempted to challenge the dam for a variety of reasons. And in some cases, held very competing views about the dam. Just for example, in the years prior to its construction, the Alberta government had considered a number of different sites for the dam. And one of these was within the boundaries of the reserve, near the town site of Brockett. And there were some negotiations between the Alberta government and the then Chief and Council over entering into some sort of partnership or co-management arrangement for the construction and operation of the dam. At the same time, many of the people that I spoke with were very clear that they were completely opposed to the dam, regardless of where it would be located, because of the impacts it would have on the river. Because for Piikani people, the Old Man River is important for a variety of very separate but also interconnected things, embodying what Yahtzee and Baldi theorize as the radical relationality of Indigenous relationships with water. As I mentioned, the larger river basin forms a significant part of traditional Piikani territory, and the name of the river and its surrounding riverbed is linked to a number of Piikani origin stories. But the importance of the river goes well beyond historic and spiritual significance. As Indigenous legal scholars, such as John Burroughs and Johnny Mack have pointed out, Indigenous stories serve to inform unique senses of place, often encoded within Indigenous legal orders, and thus help inform reciprocal relationships between people and their lands and waters. And one of the people that I interviewed, Grey Horse Rider, who was, and I believe still is currently, the chair of the Piikani Elder Society, he talked about the relationship between our societies and the lands, waters, and the beings within Blackfoot territory, and talked about this as a key part of Piikani governance before and after the imposition of the Indian Act. So according to Grey Horse Rider, many of our societies are named after the animals that traditionally lived within our territory. And as he put it, it's our duty as a Blackfoot nation to speak for our brothers, which is the four-legged animals that fly, insects, and the territory. Because with them, there's stories, the societies, they're part of our bundles, they're all part of it. So for Grey Horse Rider, then, Piikani worldviews are inherently informed by our relationships with land and water, including the Old Man River, with our traditional forms of legal and political structures, or orders, directly structured around these relationships. And prior to the dam's construction, and to some extent since, the river also provided sustenance for Piikani people. And though Piikani, like other Blackfoot Confederacy members and other Plains Indigenous people, did historically rely heavily on the buffalo hunt to sustain life, the Old Man River Valley has also been an important life source. And especially after being confined to the reserve, the river took on an increased importance in this regard. And quite a few of the people that I interviewed for this research shared their experiences of growing up along the river valley, fishing from the river, trapping, participating in ceremony, and just spending time living and socializing within the valley. So although Piikani members had a variety of opinions about the dam and whether it should be outright opposed or more a situation where the nation should seek out economic opportunities or try and mitigate the effects, everyone that I talked to seemed pretty clear about the negative impacts that the dam would have and has had on the river and the entire system that the river sustains. So Piikani challenges to the dam drew attention not just to questions of jurisdiction over the river and the riverbed, but of ontologically different geographic understandings of the Old Man River itself. As Wilson and Inkster point out, while many Indigenous nations, quote, see water as a living being, ideas about water as a resource that can be owned and exploited prevail in all the meanings within which they must contend. And I think this fundamental difference in understandings of water became central to the court action launched by the nation in 1986, which is generally known as the Piikani or Pagan water rights case. And this was an action that was intended to both challenge the dam and attempt to establish Canadian legal recognition of Piikani water rights of some kind. As I mentioned, though, this was not the only way that Piikani members attempted to challenge the construction of the dam. In 1990, while the dam was still under construction, members established what became known as the Lone Fighters Camp, named after the Lone Fighters Society, a long-standing Piikani clan. And this camp was more of a direct action, which involved using bulldozers to attempt to change the flow of the Old Man River away from an irrigation weir that had already been built within the borders of the reserve back in the early 1920s. And Piikani members also attempted to challenge the dam by intervening within the Federal Environmental Assessment Review, which didn't start until the dam was already close to completion. And yeah, at the bottom of the slides is a shameless plug. So I won't be talking about these cases, but I do have an article coming out next year talking about the research I did on the attempts of Piikani members to intervene within the environmental assessment process. Okay, shameless plug over. Sorry about that. The Piikani Nation Chief and Council, along with Louise Mandel and other prominent Indigenous rights lawyers, attempted to express these various Piikani relationships with the river through using different legal arguments that would be legible from the perspective of existing Canadian law. And when Chief and Counsel originally filed the claim in 1986, the claim asserted very broad claims to Piikani or Pagan traditional territory and jurisdiction. The claim described the ways the Old Man River and its valley was, quote, an essential living and recreational space for members of the Pagan nation. The claim also discussed how the Old Man River continued to provide fish and water to Piikani, as well as supporting hunting and trapping along the valley for food as well as clothing. And similarly, the original statement of claim argued that the dam would cause injury to the reserve, including the erosion, alteration of banks, destruction of the spiritual values of the Old Man River to the Pagan nation, as well as cause ecological changes, destruction of fish and fish habitat. And the claim asserted that Pagan rights in and to the Old Man River and the bed were never extinguished under Treaty 7. And the claim ended with a call for an injunction to prevent the construction of the Old Man River. So generally then, the original claim when it was filed in 1986 contained a very wide general list of broadly based claims to both land and water rights to the river and its surrounding lands. However, over time, for a number of reasons, and mostly based on conversations with the lawyers that were representing the nation, the emphasis on the legal case changed within its subsequent amendments, and it moved from the emphasis on challenging the dam outright to attempting to assert a form of Piikani water rights through a very specific legal doctrine borrowed from the U.S., which is known as the Winters Doctrine. Now, the Winters Doctrine was established in the U.S. following the Winters versus U.S. Supreme Court case in 1908. And as Veeder summarizes, within the Winters case, the U.S. Supreme Court ruled that although not mentioned in the treaties, there is an implied reservation of rights to use the waters and streams which rise upon, traverse, or border upon Indian reservations, which may be exercised in connection with Indian lands. In this case, it established a base for the regime of reserved water rights that exist for reservation-based communities within the U.S. So the basic underlying logic of the Winters Doctrine is that if part of government policy in establishing reserves or reservations in the U.S. Was to encourage agricultural development, then this automatically implies access to water. And in the case of lots of forms of agricultural production, it implies access to a lot of water if we're talking about sort of highest use doctrines. So the Piikani Nation and its legal team hoped to draw from this legal doctrine and this logic of the Winters from the U.S. as a means to support Piikani water rights. So from the Canadian government's perspective, there's two major policies that inform the creation of Indian reserves within what are now the prairie provinces. First, there's the securing of land surrenders from Indigenous nations in exchange for reserves and other limited treaty rights. But the second policy was encouraging Plains Indigenous nations, at least at the time that the numbers treaties were being negotiated, to encourage Plains Indigenous nations to take up farming and ranching, partly to address the collapse of buffalo, but also there was this blatantly assimilationist policy of bringing so-called civilized ways of living to Indigenous communities through adopting farming and ranching. So even though water is not explicitly mentioned in Treaty 7, it's not mentioned as a surrender, it's not mentioned as being guaranteed in any way, but despite this support from the government for ranching and farming is extensively discussed in detail in the written version of the Treaty 7. So the Winters Doctrine here then becomes a potentially useful legal instrument to articulate Indigenous water rights within Canada based on asserting it as a treaty right. If the government policy for establishing reserves was to support Indian agriculture, this support implies access to large sums of water. So in its attempts to challenge the Old Man River Dam legally, the Piikani Nation looked to this U.S. Indian water regime, beyond that which existed within Canadian legal doctrine, and attempted to assert water rights under Treaty 7. So the way I see it, the Piikani water rights case represented a strategic mobilization of the Winters Doctrine as a means to create this legal space within which to articulate Piikani relationships with the Old Man River. So rather than mobilize Piikani and Blackfoot interpretations of the treaty based on our own oral history and our own perspectives, what the Winters Doctrine does is it explicitly relies on the government's own like blatantly colonial and blatantly assimilationist policies that inform the terms of Treaty 7. So on the one hand, this is a legal argument that's no longer challenging the dam by asserting like inherent rights or inherent relationships with the water, with the Old Man River, but it's strictly drawing from Canadian and U.S. law and policy as a way to establish these rights. And I wouldn't argue this isn't inherently, these two strategies are not necessarily in opposition to each other. There are ways that this is a way of the Piikani Nation trying to instrumentalize Winters Doctrine as a way to uphold like our own relationships with the Old Man River. And finding ways to creatively articulate Piikani legal relationships by expressing them in concepts and arguments that are legible, or at least more readily legible within Canadian law. And aside from the Piikani Nation, with the water rights case, there was a lot of potential. Like the establishment to establish Winters Doctrine within the Canadian context would have created a significant shift. And because to the present day, there isn't any form of reserved water rights that the federal government recognizes within Canada that's parallel or analogous to Winters. But in the end, even this very specific instrumentalized expression of Piikani relationships with the Old Man River did not result in establishing that claim. Unsurprisingly, the water rights case faced considerable opposition from both the Alberta and federal governments because it was two cases. The case was filed in both provincial and federal courts. The Alberta government predominantly viewed and continues to view the Old Man River, the water that flows within it, as a natural resource. And within Canadian jurisdiction, water largely falls under provincial jurisdiction, which was transferred to the provinces from the federal government in 1930 under the Natural Resources Act. So in its response to the Pagan Indian Band's statement of claim, the Alberta government took the position that water rights were surrendered under the terms of Treaty 7, even though, again, the written version of the treaty contains no mention of water rights or the surrendering of these rights. The province also argued that providing water to the Piikani Reserve was only on an as-needed basis, not a reserved right. And argued that satisfying these minimal needs of water for the reserve is strictly a federal responsibility. For its part, the federal government argued that the fiduciary responsibilities are also held by the province. They're crown responsibilities, so they thus exist both in the right of the federal government and in the province. But despite this formal criticism of the Alberta government, and despite a federal court decision that had ruled that the dam construction violated federal environmental laws, in practice, Indian Affairs did not meaningfully challenge the province for failing to meet these fiduciary obligations to the Piikani Nation. So after years of slow progress with the water rights case, after the other attempts to challenge the construction of the dam proved unsuccessful, as well as under pressure from both the provincial and federal governments to settle the issue out of court, in the end, Council decided to drop the case, 1997, I believe, and pursue a settlement agreement instead, which was ratified in 2002. And this could be a whole other chapter on its own or a whole discussion, but just to be brief, the settlement agreement offered financial compensation, some limited revenue sharing, and funds for monitoring of the environmental impacts of the dam. So long as the Piikani Nation agreed to withdraw its claims, and it would agree to not attempt to establish any form of land or water rights claims to the Old Man River, to its waters, to the riverbed. So on the one hand, I argue like this court case, despite taking on the form of a civil claim, which it was, I think it represented more than strictly trying to seek financial compensation for damages caused by the construction of the dam. And at the same time, I think this case points to the tremendous, if not the inherent, limitations of trying to express Indigenous water relationships through settler colonial law, wherein I think even if the Piikani Nation had been successful in establishing Winter's Doctrine rights to the water from the old man, this is like, I would say, in terms of like legal cases, would have been like the best case scenario. The result would have just as likely been a process of converting those rights into an altogether different form of financial compensation for the damages and for the infringement on the right, rather than Winters necessarily opening up the space to reassert Piikani relationships with the Old Man River by drawing from Winters. So just to go back then, to conclude with my what I was talking about in terms of why I think like articulation has been a helpful framework for me to think through this case. I draw from the articulation in both of its definitions within the literature I cited before, both the sort of expressive and conjunctive definitions of the term. Here first, the Piikani water rights case represents an attempt to express Piikani multifaceted relationships with the old man in ways potentially legible within Canadian law. At the same time, this attempt to express Piikani relationships within the Canadian courts served to reproduce a relationship of dominance, wherein Blackfoot law articulates within Canadian law in a way that is subordinate to Canadian law. So even when translated into a Canadian legal framework, the Alberta government was simply unwilling to recognize Piikani water rights claims, insofar as they posed a direct challenge to the government's ability to facilitate the accumulation of water from the Old Man River for economic purposes. So I think this experience with trying to challenge the Old Man River Dam through litigation is important, and it's instructive, I think, in terms of some of the possibilities, challenges, but also limits to Indigenous expressions of law. I think there's certainly a lot of transformative potential in movements that are oriented around assertions and reassertions of Indigenous legal orders, and especially like in the Canadian context. I think some of the most exciting and inspiring and effective forms of Indigenous political struggle are rooted in these assertions of Indigenous relationships with our lands, territories, animals, plants, and the other beings with which we share our territories. At the same time, I don't think that potential is a given. And this is something I'm trying to emphasize in my research on the Old Man River Dam. That's something that Indigenous communities need to consider when, rather than asserting our own forms of law, like on our own terms, what are the kinds of limits that arise when we attempt to articulate our own forms of law within and through the languages, structures, and institutions of settler colonial states such as Canada? So that's everything I had to share today. Thank you for listening. Niksukwa.